Okay, I see that we are getting ready to bring a close to the break that we took. And we're getting ready to start our third and last panel for the day. I hope many people who are out there who are participating in the webinar got a chance to see the programming earlier. I don't know if we have some diehards who've been here all day, but hopefully there are some of you as well. It's been an amazing day, and I have so appreciated the hard work and the insights and the brilliance that people have brought to the table. So just really rewarding. I'm happy to share that we have our final panel for the day, and it's entitled Noncitizens, Exclusion, and Enforcement. And so this panel is going to go to 4 o'clock Mountain Time. And at that time, we're going to move into a virtual reception. So we will give you a link. That link will be posted in the chat. And you can go to that link, and that way you'll be able to join the reception. So we will formally end the conference. And for those of you who would like to do a deeper dive, join us in some of these conversations, or learn about actions that you can take that might interest you based on the things you've learned, then please do join us in these breakout rooms, and you can pick whatever topic you want that's offered and just chat informally with other people and learn a little bit more and tell us what's on your mind. So we hope that you will stick with us. That will be at the very end. After this panel, we'll take a break, and then we'll have our virtual reception. So I'm excited to bring to you this panel. The panel is going to be moderated by Hunter Knapp. And so Hunter is a postdoctoral research fellow at the University of Colorado Law School. His research focuses on race, immigration, and administrative law. As a student, he published an article called Managing an Administrative Emergency, Establishing FEMA as an Independent Agency. And he published that with our journal right here at the University of Colorado, the Natural Resources, Energy, and Environmental Law Review. But he did not stop there. He has co-authored a piece with Professor Chen, and their article is called The Political Misrepresentation of Immigrants in Voting. And that's going to be coming out soon in the Colorado Law Review. So we're excited to see your work, Hunter, and what the two of you have come up with. Hunter is also a member of the steering committee of Project Protect Food Systems, and that is a nonprofit that serves Colorado's agricultural workers. So that is Hunter. Hunter, we are so glad to have you, and you'll be moderating this panel. You are in good hands. I'm going to turn it over to Hunter at this point. And as I said, we will be closing about 4 o'clock. For those of you who want to ask questions, you're welcome to pose those questions in the Q&A if you are part of the webinar. Not so much if you're watching the live feed, but the webinar folks have that capacity. So thank you at this point, Hunter. You can take it from here.
Thank you, Professor Malveaux, and thank you to our panelists and everyone who's joining us at the third and final panel of our Rothgerber conference. We will be exploring the impact of harsh enforcement and exclusion policies on non-citizens with our panelists who bring perspectives from law, history, and political science. Moderated discussion of the issues will be followed by a Q&A portion. So as Professor Malveaux said, please submit your questions through the Q&A button at the bottom of the screen. First, I would like to introduce Evan Smithers, a second-year law student at the University of Colorado and a member of the Colorado Law Review. Evan is passionate about civil rights and litigation and will be working at the Jackson Lewis Law Firm in Denver this summer. Now, Evan will introduce our esteemed panelists.
Thank you, Hunter. It's my pleasure to be able to introduce to you all 4 incredibly accomplished panelists that are joined here with us today for our third and final panel of the Rothgerber Conference. First, we have with us here today Professor Adam Goodman. Professor Goodman is an assistant professor in the Latin American and Latino Studies program, as well as the Department of History at the University of Illinois at Chicago. His research interests include migration history and policy, Mexican American history and Latino history, and border and borderlands history. Just last year, Professor Goodman published a book titled The Deportation Machine, America's Long History of Expelling Immigrants. In his book, Professor Goodman uncovers public officials' use of force, coercion, and fear to purge immigrants from the country and exert control over those who remain. Second, we have here with us Professor Rebecca Hamlin. Professor Hamlin teaches with the Department of Political Science at the University of Massachusetts. Her research is focused on law and immigration politics, and she has a particular interest in migrant categorization and the concept of a refugee. She has published articles on the history of American asylum policy, comparative refugee status determination systems, and politics of migration and media in the UK, and the blending of international criminal law and immigration law to remove suspected war criminals and human rights violators. Third, we have Professor Shoba Sivaprasad Wadhia. Professor Wadhia is a professor of immigration law and refugee and asylum law at Penn State Law School. Her research focuses on the role of prosecutorial discretion in immigration law and the intersections of race, national security, and immigration. She has published more than 30 law review articles, book chapters, and essays on immigration law, and we're happy to have her here today. And last but not least, we have with us Laura Lunn. Ms. Lunn is the Detention Program Managing Attorney at the Rocky Mountain Immigration Advocacy Network, where she practices removal defense for non-citizens detained in Aurora, Colorado. While her caseload varies, her primary focus is providing court-appointed legal representation to individuals determined to have limited competency through the National Qualified Representative Program. Now, it was my pleasure to introduce to you all our esteemed panelists, and I'll turn it back over to Hunter to begin the discussion.
Wonderful. Thank you, Evan. Before we get started, I would just like to remind all our panelists that they're welcome to respond to their fellow panelists' comments. Now, let's dive into our discussion. My first question is for Professor Adam Goodman. Professor Goodman, your recent book, The Deportation Machine, traces the long and troubling history of the U.S. government's systematic efforts to terrorize and expel immigrants. In the late 20th and early 21st century, Democrats and Republicans reached consensus on an immigration system that prioritizes enforcement and the deportation of undocumented people. How did the history of racist and nativist immigration policies lead to the current environment of the enforcement era?
Well, thank you, Hunter, for that question. And just a quick thank you to all the organizers and fellow panelists. I'm really looking forward to the discussion. And congrats to Professor Chen. It's so exciting to be here to celebrate the book together. And I think it generates so much in terms of the area of interest that I have related to immigration enforcement historically, as well as thinking about more contemporary topics. But one of the things you mentioned is that this is a long bipartisan history that I trace. My book starts in the late 19th century and goes up until the end of the Trump administration. And I think some people, perhaps not those on this conference or at this conference, but some people might not realize that the history of punitive immigration enforcement policies dates back more than a century. And Democrats and Republicans alike have really supported extraordinarily punitive, inhumane policies. And now we might be seeing perhaps some moment of change as immigration politics have become more polarized. But it's important for us to kind of keep in mind the different factors that have, I think, driven deportation and punitive policies over time. And the many things that I identify in the book included kind of the bureaucratic inertia and imperatives that, regardless of who is in the White House, perhaps, the immigration enforcement bureaucracy has a task to carry out immigration enforcement as stated by the laws on the books. And they want to apprehend as many people as possible. They want to deport as many people as possible so they can celebrate their so-called accomplishments and request more money in the next congressional budget appropriation. And as long as that remains the case, I think there will be a question of kind of the gap between the policy on the books, however liberal and welcoming it might be, or however punitive and restrictive it might be, and enforcement on the ground. One other thing that I would say that really matters certainly are the capitalist interests that have driven migration to this country, and the immigrant labor demand that we have had and depended on, as well as you mentioned, sometimes racist imperatives, either the laws themselves or the implementation of them by the bureaucracy, or sometimes even individual officers that are carrying out the laws on the books. I did want to mention that so much of the story that I trace is one of continuity. but they're also important moments of change. And I think one of those moments, and this ties back to the first panel of today, in which Professor Chen and Professor Motomura were having a really interesting discussion. I think, well, when does the enforcement era begin? And I think we could trace these different strands back really into the late 19th century, but there is a key moment of change that I identified really in the middle to late 1970s. And it's at that moment in time when immigration enforcement and the possibility of being deported becomes an everyday reality for so many people in the country without authorization. So from 1978 to 2008, during that 30-year period, an average of around 900,000 people are deported each year. And that did mark a significant moment of change. And I think that that's something that we can be mindful of. And that's perhaps the beginning of what I think of as the dawn of the age of mass expulsion. So I think that we can recognize the continuities, we can recognize the ways in which the previous presidential administration was historically bad and really did such damage to immigrant communities, while also acknowledging the fact that Democrats and Republicans alike have contributed to this punitive system.
Excellent. Thank you, Professor Goodman. You mentioned the complexity of enforcing immigration law and the constantly growing apparatus that handles that. But US law did not always include such rigorous means to prove someone's immigration status and potentially deport them from the country. How have violence and then practices including voluntary departure and self-deportation been used by the federal and state governments to target minority groups for deportation throughout history?
And you touched on one of the real, I think, surprising findings of my research, and that was the fact that 57 million people have been deported since the 1880s. And 85% or more of those individuals were deported through other means, the euphemistically termed voluntary departures, which are not voluntary at all. I mean, these are administrative expulsions that happen after someone is apprehended, and immigration officials coerce, pressure, convince, or sometimes even trick people into agreeing to leave the country without staying and fighting their case through the courts. And those represent 48 million of the 57 million deportations throughout US history, right? And scare tactics, fear campaigns, restrictive policies meant to make people's lives so miserable that they pick up and leave through self-deportation, we might call it, as Mitt Romney kind of put it in his 2012 presidential run. Those policies have also played an important role in expanding the power and the authority of the immigration bureaucracy, right? So if they're limited in terms of their budget and their means as to how many formal deportations they could carry out, they figured out creative ways around those limitations. And that's something that I think we really see, that if we don't take into consideration, we're missing the vast majority of all expulsions from the country. And if you speak with migrants, if you speak with people, as I did during my research, doing interviews and oral histories, they oftentimes don't distinguish between which bureaucratic, right, or juridical mechanism they were removed through, but they know that they were removed from the country. And that was something that really stood out to me. In addition to the fact that oftentimes it targeted citizens and US permanent residents, right? And this is something directly tied to Professor Chen's work as well, where if we think of the limitations of citizenship and the fact that the disproportionate targeting of Mexicans throughout the 20th century oftentimes led to mass raids that would scoop up anyone who looked Latino or looked Mexican. And there are numerous cases, including some that I trace in the book, of young teenage permanent residents who are apprehended and deported, and then activism that occurs in response to that. And that's something that we see being more of a through line, I think, in terms of the continuity than not. And in part, it's because of these different policies and expulsion mechanisms that officials have relied on. And just the final thing I would say on this is that, as many of you probably know, after 1996, the number of formal deportations increases so dramatically because of the change in law. And because of after 9/11, just the enforcement budget really just increases exponentially. But what we've seen is that formal deportations, right, which carry with them harsher consequences, and oftentimes have been by order of an immigration judge, those have become very streamlined, right? Those are oftentimes expedited now as well, such that they resemble the voluntary departure in their fast track nature, but they carry with them harsher consequences. So we see that deportation, what it means to be deported, has changed over time. and the consequences of being deported today are harsher than they have been in the past.
Thank you so much for that response, Professor Goodman. I feel like it really sets up a lot of the conversation we're going to be having today. One thing you mentioned is that despite the voluntary framing of these deportations, many of the affected people arrived in the United States while fleeing from violence or persecution in their own home country. Professor Rebecca Hamlin, your book, which was released this week, Crossing: How We Label and React to People on the Move, criticizes the binary treatment of recipients of refugee status compared to other migrants. Oh, yep, and thank you for sharing that book. Please go out and buy it, everyone. So it criticizes the binary treatment of recipients of refugee status compared to other migrants. Throughout the 21st century, economic pressure and environmental disasters that are currently driving migration will continue to drive migration to the United States, but neither of these groups are eligible for refugee status. How can we improve US law so migrants fleeing disasters not covered by refugee laws are treated more equitably once they arrive in the United States?
Thank you, Hunter. And I'll just quickly echo Adam's gratitude for being a part of this whole endeavor. And thanks a lot for the shout out about my book. I feel like I maybe somewhat defensively need to clarify in the context of speaking in a law school that I'm not arguing against having legal categories that distinguish between different types of people who are seeking access to the United States. It seems to me that something of that nature, unless we end up with open borders, is inevitable. And that laws inevitably prioritize some types of needs or some types of suffering over others. Instead, I'm arguing against slipping into what I call an essentialist logic that assumes that some people just are refugees, like that there's some sort of secret answer to the question of which people are allowed to come here under those auspices and which people aren't, that could be somehow discovered through a process of regularized bureaucratic or legal inquiry. So part of the reason why I'm disturbed by that notion is that it seems fairly obvious to me, and I'm grateful to the work of historians like Professor Goodman who have traced this out, but fairly obvious to me that refugee status has always been a political construction in this country, and it's always been deployed in ways that favor particular types of suffering, particular types of groups, aside from the actual words of the language itself, which is also a particular political product of its time and place. And so what I'm really concerned about is the ways in which not just politicians, but very often politicians, and then almost reactively, reflexively advocates and also scholars like myself of migration tend to sort of use the migrant refugee binary as a shorthand that then frees us from doing the really hard work and having the really difficult conversations about what we actually want to prioritize as a country, right? There's this assumption that we don't need to have those difficult conversations because the categories themselves have already done the work of answering the question of who is deserving. And I think that there's this really interesting historical resistance, which I talk about in some detail in my book, to viewing in particular our US-Mexico border as a site of direct arrivals of people with real humanitarian and protection needs. Rather, there's this assumption that our border is a place where economically motivated and thus undeserving people arrive. And so the binary logic that distinguishes between migrants and refugees often serves to make really harsh border control measures that we've seen escalated and enhanced at the border more ethically palatable to the American public, because we can say, don't worry, it's not refugees that are being turned away there, it's just migrants. And that type of work for anybody who knows this issue at all, really erases the lived experience, as you say, of the people who are coming. It's oftentimes there's this conflation that we saw at its worst when Fox News talked about 3 Mexicos in Central, instead of talking about actual Central American countries, right? It's often used to conflate anyone arriving at the border with a Mexican, and then to assume that those people are only economically motivated, which erases not only the experience of people coming from all parts of the world to the border, but also the experience of a lot of Mexican people who are trying to cross over, who themselves are fleeing things much more complicated than just economic difficulty. So what I'm really appealing to in the book is a need to have the most difficult conversations, again, about the people that are arriving, many of whom clearly have significant protection needs. That's obviously easier said than done in this political context. I know that. But to really answer your question, I think that we can improve on US law by getting out of a binary logic that makes these conversations seem less necessary, and think about the Refugee Convention as just one of many tools for addressing vulnerability at the border, and by advocating for legislation that would create other types of protection categories that would be viewed not as subsidiary or secondary, but would be equally worthy.
Wonderful. Thank you for that clarification. I definitely understand better now. My next question concerns Professor Chen's book, Pursuing Citizenship in the Enforcement Era, which is the subject of our conference. She argues that simply removing the threat of deportation is not enough to enable people to achieve full citizenship, but substantive economic, social, and political requirements or components are also necessary. Currently, recipients of refugee status receive some support from nonprofit organizations and the Refugee Resettlement Agency to help them make the transition and complete the naturalization process. As you were describing the need for some alternative programs outside kind of the 1980 Refugee Convention, would you suggest that we model those programs after the current refugee policy? By that, I mean, should we provide funds to help other migrants complete language classes, find jobs, and just provide general support?
I love that you asked this question, Hunter, because many people here today might not know that Professor Chen and I go way back. We went to graduate school together, and we have a shared mentor in Professor Irene Bloomrad, who's at University of California, Berkeley, and she's written about this very question. So I think, until I really heard your question, I hadn't thought about the ways in which Professor Chen's book and my book both sort of, you can see the lineage there of our intellectual mentors. But in Professor Bloomrad's comparative study looking at integration policy in the US and Canada, what she found is that greater state support for integration of people on the path to citizenship makes a huge difference. In the US, that state support exists primarily for people with refugee status, but not for others, as you've said. But in Canada, it's more of an across the board type of support. And Professor Bloomrad in her book finds that this across the board support has a huge impact on naturalization rates and later political engagement of people who've gone through the naturalization process. So yeah, I think that a binary logic that casts some arrivals as needy and deserving of support and then leaves others to fend for themselves really plays into these dynamics. And if we get away from this logic a little bit, I think it would be better for the vision of full citizenship that Professor Chen outlines in her book. Absolutely.
Wonderful. Thank you, Professor Hamlin. And thank you for that comment about Professor Blomrad. It was interesting. As a student of Professor Chen for the past few years, I feel like I've kind of joined the next generation of that intellectual family. So thank you. That was cool. To turn to our next panelist, one of the things Professor Hamlin spoke about was the large number of people with compelling humanitarian reasons for remaining in the United States who don't qualify for refugee status. This group of people has prompted the executive branch to exercise prosecutorial discretion throughout the enforcement era. Professor Wadhia, your recent book, Banned Immigration Enforcement in the Time of Trump, examines former President Trump's use and misuse of discretion during the first 18 months of his term. During this period, the Trump administration pursued harsh enforcement policies, including the attempted rescission of DACA and the Muslim ban. Later, he would pursue student visa rules related to the COVID-19 pandemic that also excluded people harshly. All these policies negatively impacted immigrants and their families. Professor Wadhia, what were the effects of these policies and how do they tie to the idea of formal citizenship?
Thank you, Hunter, and I will join the chorus of thanking all the organizers. I'm really honored to be here with my co-panelists and to also engage Professor Chen's book. But in short, the effects of the policies you just described, which in fact were discretionary choices and by no means legal requirements, have been profound, and they've been motivating factors for what Professor Chen labels as defensive naturalization. And it's pretty ironic that for people directly affected by these policies, even formal citizenship is out of reach. With regard to DACA, a policy that necessarily hands legal limbo or deferred action to those who qualify, the previous administration tried to end it. For DACA recipients, I had a real connection to Professor Chen's book because I too interviewed DACA recipients and received sort of similar sentiment around feelings of belonging, but great uncertainty. Also just a heightened mental toll. One person I interviewed said, I think it's not so much the effect of the policies that are being enacted, which are dangerous and poisonous to our democracy, but it's the psychological warfare that we're subjected to on a daily basis. We live in a time where the president can just pick up the phone, send out a tweet, and then you spend the whole day deciphering it. How bad is it? How bad isn't it? That's followed by really bad actors across all agencies that are trying to diminish any sort of real idea that this nation continues to be a nation of immigrants. And at tension with this mental toll is a lack of access to formal citizenship, as well as a strong sense of belonging, which Professor Chen defines as a feeling one has a meaningful life in America. With regard to the Muslim bans, there were actually three versions. The version that survived the courts was issued as a presidential proclamation and issued by the Supreme Court on statutory and constitutional grounds, and later used as a foundation to extend to nationals from 6 largely African countries, which is why today it is known, or its legacy is known as the Muslim and Africa ban. The section of the statute, I guess I will talk about a legal section, used to enact these bans is section 212F. And it's important as we think about Professor Chen's book because it is a highly exclusionary section of law that gives the president the power to suspend the entry of any person or group of persons if their entry would be detrimental to the interests of the United States. And the effects of the Muslim and Africa ban were multifaceted. Missed milestones, and what is perhaps the greatest untold story of family separation. I'm at Penn State, and you may not think about it in central PA, but then again, you may, given where you are located. But Penn State was the 4th most affected university in the country by the first Muslim ban. So it's something that was very much impacting my own backyard. One person I spoke to about the Muslim ban really talked about these missed milestones. And she said, the common thread I see among every single person that walks into my office is, I need my mom because I'm going to be in labor and I can't do this without her. Or I'm the first person in my family to get a PhD. It would be the world to my parents to be there at my graduation ceremony. Or I'm in love and I'm getting married and I'm getting engaged. And this is a huge moment in my life. And I would like my parents to meet my future husband. These are the moments that we normally share with family, and they were destroyed for people because of the ban. Professor Chen ties the story of the Muslim ban to citizenship in describing the early days of confusion when people thought that LPRs or lawful permanent residents or green card holders who were from one of the covered countries were also subject to the ban. And she makes an important point that even though that got fixed up, right, where the government said, oops, sorry, LPRs are exempt from the ban, even if they're from a covered country, it still left this taste in the mouths of green card holders that was somewhat fragile, that was tenuous. And I would like to add to that even further by saying that even US citizenship relationship was fragile because of the ban. Scores of people who were the children or the spouse of US citizens in legally qualifying relationships were unable to enter the United States because of the Muslim and Africa ban. We often think of being married to a US citizen, right, as the sort of fundamental way under family that someone might acquire permanent residency. But in this case, even being married to a US citizen was insufficient. And as of 2019, more than 9,000 spouses and minor children of US citizens were barred for no other reason because of the ban. Finally, with regard to students, students were directly affected by DACA as well as the Muslim and Africa ban, but there were specific policies that targeted them. One we all might remember from last summer was an announcement by ICE saying that it would no longer provide exemptions for students who were taking a full-time online course load because of the pandemic. And so the policy said that if this is you, you need to leave the United States or else face deportation. Another student policy that was published affected people who were entering by changing the rules of someone's period of authorized stay from being tied to their course of study to being a fixed time, 2 years or 4 years, depending on country of birth. These policies did not go into effect, but they really increased the vulnerability of international students and sent a message that they are unwelcome.
Thank you, Professor Wadhia. I have a follow-up question on that, given how well you explained kind of the broad impacts of the discretion afforded to the president and how it can negatively impact even US citizens who have family members who are impacted. Given that the judiciary has shown little willingness to kind of contain the president's discretion in these areas, is there anything that Congress could do to limit the ability of future presidents to change immigration policy in such extreme ways overnight?
Well, there are several things that Congress could do, but as we now have sort of digested on what it means to belong, that may not necessarily be sufficient. I'll just give you one example to keep the conversation going, and that is the No Ban Act, which has been introduced and is part of the comprehensive immigration bill that was introduced in both the House and Senate. So the No Ban Act was introduced as independent legislation in the last Congress, but then incorporated into this comprehensive bill. It would set limiting principles on that section of the statute I just mentioned, Section 212F, by requiring the president to have a specific reason, by putting time limits on the suspension of any entry, by including religion and non-immigrant to the non-discrimination clause of our statute, and by having a humanitarian exemption for those who are covered. So that's just one example of what Congress has done with respect to the Muslim ban.
Thank you. You mentioned kind of the early actions of the Biden administration, and one of these includes the appointment of Alejandro Mayorkas as the Secretary of the Department of Homeland Security. He was one of the architects of the DACA program back during President Obama's administration. And in my opinion, this indicates that the Biden administration will return to a lot of Obama-era discretion and enforcement policies, at least until a hopeful passage of the US Citizenship Act. How would you recommend that Biden and his administration use the lessons learned during the 2008 to 2016 period to guide their use of discretion in immigration enforcement in the 2020s?
So it's a big question, and it's pretty tempting, right, to interrogate the policies of the Obama administration as a way to guide policy in the Biden administration. You know, in the space of enforcement discretion, President Obama, as you mentioned, announced DACA, developed a prosecutorial discretion policy. Some came out in the Morton memo or in the Johnson memo, both defined prosecutorial discretion, listed what many might call imperfect priorities, and also listed equities officers should consider when making discretionary decisions. And alongside this was a real tension, right, with the Obama administration's use of detention to hold families, including right here where I am in Pennsylvania, and a record number of deportations. Ultimately, I don't think the Biden administration should rely on the policies of the Obama administration to serve as a guide for discretion. Rather, I think discretionary choices should be guided by principles and a shared understanding that how discretion is used matters. And this is an argument that runs throughout my work, including my first book called Beyond Deportation, which really takes you through a history of prosecutorial discretion from the early 1900s to the present. Historically, discretion has been applied favorably when a person has equities or humanitarian qualities like long-term residence, a serious medical condition, being a survivor of crime, being of an elderly or advanced age. The idea of using discretion to favor the non-citizen is particularly important in the context of a very strict immigration statute that excludes many non-citizens from obtaining any status at all, and because of the particular harms that flow when discretion is denied. Misuse of discretion can result in harms to the individual, but also to families and to communities. Discretion is also essential to the rule of law. So when we think about discretion as an instrument, we have to think of it as part of the immigration system. One former INS official I interviewed in writing Banned said it this way: the meaning of the law has always included law and equity. That is the rule of law. Fairness plus rules. One without the other is not the rule of law. The principle guiding President Biden's policy on paper is humane immigration. In the first month, the administration has used discretion to rescind the Muslim and Africa ban, preserve DACA, and issue guidance on civil enforcement priorities and prosecutorial discretion. This is a good start. But to the extent that those who were previously excluded might someday qualify for citizenship, I'd like to end by amplifying a point made by Professor Chen. Quote, improving the daily lives and future prospects for those immigrants who have been excluded from society requires affirmative institutional support that fosters both formal citizenship and substantive belonging.
Thank you, Professor Wadhia. I think that was a great point to close with, and one of the things I really drew from Ming's book and her lessons over the years, or Professor Chan's book. So this complex web of discretionary policies and laws that have developed over the years, they do include opportunities for equity, as you mentioned. But navigating the maze of these policies and laws can be a difficult task, and especially if the person doesn't have a lawyer. Too often, respondents in immigration court are forced to appear pro se. For more than 20 years, the Rocky Mountain Immigrant Advocacy Network, also known as REMAIN, has been leading the defense of non-citizens in Colorado seeking to avoid harsh enforcement and deportation. Professor Lunn, based on your work as a managing attorney at REMAIN, how does access to counsel impact the ability of people to succeed in immigration court and then ultimately make the transition into U.S. society?
Well, that's a wonderful question. I'll get to it in just a moment. I just want to echo the thanks, especially given that I'm on this panel with a number of brilliant scholars, and I am mostly a practitioner. So it's really wonderful to kind of hear from your perspective, to step back and in the aggregate understanding these systems in a totally different way than I experience it working with clients on a daily basis. So I should start by saying my focus today is going to be mostly on people in immigration detention, because that's my area of practice. But all of this goes hand in hand, trying to figure out how to elevate people's ability to access citizenship in this country. Because so frequently I encounter clients in detention who are lawful permanent residents, have had their residency for like 3 or 4 decades, and now they're in removal proceedings because they did not naturalize. And that is the most heartbreaking type of case you can encounter in my mind, because they have strong family units here. Typically they're grandparents to many grandchildren and children. And so had they had access to counsel at many stages prior to their the Department of Homeland Security's attempt to deport them, I should say, it just would have made a world of difference and prevented them from ever even being ensnared in the immigration system detention regime. So I guess the main thing I would like to kind of hone in on is the fact that the United States wouldn't be able to implement the detention regime that we have today had it not effectively created this psychological distinction in the minds of Americans that create like an us versus them mentality between US citizens and then people placed in immigration proceedings and in particular in immigration custody. And that this narrative has provided each administration in recent history with a tool that allows them to justify harsh immigration enforcement and the imprisonment of non-citizens and sometimes citizens, right? Which I think everyone's alluded to here. And so I think recognizing the importance of having access to counsel is really important because how complicated our immigration laws are, right? So, you know, immigration court is the only legal proceeding in the United States where somebody can be detained without a lawyer. You know, when I started working at Remain about 5 years ago, the number of people in immigration custody in Aurora, Colorado, without access to counsel was 91% of the people that detained there. We've made a lot of inroads in under the Trump administration in terms of expanding access to counsel because so many foundations and government entities have decided that this is a valuable area to invest in order to be able to expand access to counsel. So now the figure is closer to about 70% of immigrants in civil detention are unrepresented. So we've at least brought the number down a little bit. But it's creating vast disparities in outcomes based on income levels. So a lot of people have access to counsel purely by virtue of their ability to pay an attorney. Obviously, that's a lot more challenging if you're detained because you are unable to work. And we're not going to get into the type of labor that people perform in detention that clearly cannot account for the cost of counsel. And so the vast majority of people who are represented, at least in our facility in Aurora, are represented by pro bono counsel or low bono counsel, depending. And studies show that representation may be the single most important determinant of success in immigration cases. So detained people are 10 times more likely to have a positive outcome in their case, to win their case, if they have counsel than if they don't. And of note, we're always paying the government attorney to represent the Department of Homeland Security in immigration court, right? And they always have a seasoned immigration attorney advocating for their position. Meanwhile, we have the respondents in court sitting there by themselves largely unless they're able to afford counsel. And so they're being forced to navigate this very complicated area of law in order to fight to stay in the United States. And what's at stake here is usually their access to their family if they've been here for a long time, or in many cases, we're talking about asylum seekers who are afraid for their lives should they be deported. So the stakes are extraordinarily high in these proceedings, yet we don't afford people the right to counsel. And I also just want to highlight the fact that their access to counsel also kind of peels back this veil of what is happening in immigration detention. Because when you have an attorney, they can advocate on your behalf. They can share your story with the press. They can talk to community advocates and connect you with all kinds of other people instead of feeling siloed inside of a detention facility where you don't really have access to anyone in the outside world. And so having access to counsel not only provides you access to due process and to justice, right? But also this access to human contact. And I think what I would really like to highlight, especially given my area of practice where I largely represent people who have been deemed mentally incompetent by the immigration court, which just highlights the inadequacies of medical care in immigration custody. And there's a really great case, Fryhat v. ICE, that goes through and addresses, like, here are all of the systemic failures that ICE is performing across the country in immigration detention, such as access to timely medical and mental health care, specialty and chronic care, trained and qualified personnel to administer the care, timely emergency health care, all of these facets, right? And so what we are seeing beyond just the stripping of people's access to justice is they're stripping the access to health care. And we saw in 2020 a peak in the number of deaths in detention. And just like taking a step back to really examine, what is the system that we're talking about? Why would somebody have to die because they're trying to seek access to justice in their immigration case? It doesn't make logical sense. And I think it really highlights the fact that if you are able to provide an attorney to someone, they're not just advocating on their behalf in their legal case, but they're advocating on their behalf in all kinds of different facets of their lives.
Thank you so much for both your work and that window into immigration court and the detention process. That was very illuminating. One of the things you mentioned is that people are essentially prevented from paying for their own immigration lawyers because they are kept in detention. Under the Trump administration, we witnessed the largest population in immigration detention in US history, rising to about 60,000 people by early 2019. Due to the COVID-19 pandemic, there was an unanticipated effect of significantly reducing the number of people in ICE custody, with only about 14,000 people in immigration detention currently. Given this landscape, do you anticipate detention numbers will rise again? Or do you think this creates momentum for advocates seeking to end the use of our incarceration in the immigration context?
Well, I was actually just on a call yesterday with a bunch of immigration advocates, and we were, talking about, what we should anticipate with ideally the end of Title 42, where people are being excluded from the United States, and the wrapping up of the migrant protection policy or remain in Mexico policy, where people have not been able to come into the country for so long to access the immigration court system. And so we were all kind of talking about it and, what should we anticipate? And I think we all are quite traumatized from the Trump administration because we're like, it's very quiet. There's not that many people in detention. What terrible thing is about to happen? So I would like to believe that the Biden administration is going to take traction from this number and say, okay, well, let's refocus. Let's, instead of allowing people to enter the United States and put them immediately into detention, which has been the regime for many, many years, is can we use some type of alternative to detention and increase access to counsel such that people can know how to show up to court? Can we administer more types of alternatives to detention, like the Family Case Management Program, which provides social work support to people so that they know how to, find their bus route to get to court. They know what kind of services are available to them. I have the privilege of working with social workers at Remain who provide that type of support to our clients. And it is remarkable to see not only how much insight they gain to just operating and navigating life here in the United States, but also insights into their past trauma by having access to counseling and trauma-informed care. And so recognizing the humanity of people and recognizing that the best thing for them in order to access the judicial system is for them to not be detained, is for them to be able to gain work authorization immediately so that they can work lawfully and they're not worrying about whether or not they're doing something that's unlawful, right? So that they're able to either hire counsel or have the US government provide counsel, which would be my preferred path. And then have the ability for them to access benefits, for their children to be able to access schools instead of putting them in family detention. And all of these facets of what it means to immerse yourself into our communities such that you're able to access the judicial system, sure, but you're able to contribute to US society in a way that you're not able to if you're behind bars. And so I think that having some type of a paradigm shift in this country is necessary for us to reframe, like, what is it that we're doing here? What are our values? What are our morals? And why are we putting people in this situation when they equally could be out in our communities and thriving, rather than spending a huge amount of money detaining people in a situation that is tantamount to torture in certain circumstances. And as I mentioned, people are passing away because they're being forced to remain in this type of a custody situation. And so I think that the best thing that could happen from this huge reduction in custody is just that we all re-examine the system and change it such that we do not use detention for immigration enforcement any longer.
Thank you so much, Ms. Lunn. And just as a final note on the things you were discussing, there have been limited studies that show that when provided with immigration lawyers, even if they are released from detention, respondents in immigration court are overwhelmingly likely to complete the full process if they do have access to counsel. So that's just one more point in favor of that. And I would like to thank all of our panelists for that wonderful introductory discussion. Now we're going to turn to a bit more of a roundtable discussion with some give and take between all of our wonderful panelists. Before we move to that, I would like to remind everyone who's watching to please submit your questions for the final Q&A portion at the bottom of the screen. Now, turning to our roundtable discussion, I believe it was Professor Wadhia who brought up Ming's discussion of defensive citizenship, or the formal pursuit of citizenship in order to protect oneself from deportation. There are currently more than 1 million people living in the United States with DACA or TPS who did not have the option to seek defensive citizenship when the Trump administration decided to attack those people by attempting to rescind DACA or limit TPS status. I want to know how the US should ensure that people who currently have limited protection through DACA, TPS, or one of the other deferred enforcement schemes, how can these people secure economic, social, and political aspects of citizenship while they are in that legal limbo? And how can they potentially secure legal citizenship one day? So I'll first put that to Professor Wadhia.
Well, thank you for the question and this discussion. And I think the the second part of your question's easier to answer than the first, and that is, you know, the pathway to potentially achieving formal citizenship would require legislation, right? Because, you know, TPS is in fact grounded in the statute, so it's a little bit different from DED, Deferred Enforced Departure, and DACA. It does provide a durable status, but it is temporary. It does not provide an independent pathway to citizenship. So if we look at some of the legislation that has been introduced in the prior and current Congress, it would provide a mechanism for TPS, DED, and DACA holders to regularize their status first permanently and eventually to US citizenship. And I think it's a great policy choice, even if we look at the equities and the fact that these are populations that have lived in the United States for decades. So they've built their lives here, and they have the kinds of equities that we've seen historically apply in legislation. In terms of what do you do now, right, with legal limbo? I mean, that's a deep question that I'll start to answer and then maybe pass the baton. You know, one benefit, I put that in quotes, of these three types of statuses is that you can apply for work authorization. So the ability to apply for work authorization is quite important for a TPS, DED, or DACA holder because it does provide more agency. My study and others also show that it just provides agency not only for the individual, but for their families, right? Because they're the ones that might be able to drive their mother to work if mom is undocumented, or to help support the family. I think one great source for this mobility while in legal limbo is in fact our institutions, our educational institutions, as well as our private ones. So what does it mean for even a higher ed institution to provide support to those who have DACA or TPS or DED or who are undocumented, right? We certainly have these populations here at Penn State, right? What does it mean to not require anyone to self-select, but to make sure they have all of the resources they need to live a healthy life and thrive, whether it's mental health support services or financial support to pay for tuition, or community forums where, you know, hashtag you belong here, right, is the message that resonates in the communities that they live in and the institutions where they go to school or work.
I would just build on that last comment in particular. I mean, I think it's so important. And, you know, here in Illinois, within the last couple of years, there's a successful campaign to pass the RISE Act, which provides financial aid for undocumented students and other students from marginalized groups. And, you know, that was only possible through organizing and sustained struggle and political pressure over a long period of time. And I think that's what we're seeing now as ever, that, you know, many of these battles will not necessarily be won quickly, but over time they can, you know, pay enormous dividends that make tremendous difference in the lives of so many people who live in this country. And there also is a particular moment of opportunity here, I think, regardless of perhaps the current administration's shortcomings or the ways in which, you know, they haven't implemented as progressive immigration policy changes as some would like. And they have done a number of things, as others have mentioned. It's helpful to have a common enemy in a sense. And I think immigrants and advocates and allies have realized that during the last 4 years, during the previous administration, more people came to understand immigration as a crucial policy issue and as one that affected the lives of people in their communities, citizens, non-citizens, permanent residents alike. And that does create certain opportunities for organizing and sustained, you know, activism. Now, whether or not that continues or whether or not kind of people think that because Joe Biden, you know, won the election in November, now we can kind of move on with our lives, that's an open question. But I think there is a possibility now that is potentially, you know, promising.
Thank you so much. Unless any of our other panelists have comments on that question, I'll turn it over to Evan for another group question.
All right. Well, I'll ask away. So during the lunch panel today, several DACA recipients shared their stories and expressed the desire to escape the legal limbo of deferred enforcement policies. However, the goal of comprehensive immigration reform has eluded Congress for decades. So my question to you all is given the difficulty of reaching consensus on comprehensive reform and the current partisan balance in the Senate, should legislation protecting DACA recipients be pursued separately from President Biden's proposed Citizenship Act of 2021?
I mean, I guess I'm a political scientist, so I'm supposed to jump right in here. Yeah, I'm very concerned about the political possibilities for a comprehensive immigration reform act. I think that the issue of immigration has become, over the past 25 years in particular, you know, when I started in graduate school, we learned about it as what's called a cross-cutting issue, right? One that brought strange bedfellows together across political parties in interesting and new ways. I don't think that's true anymore. I think immigration has become much more of a partisan issue, in part for some of the reasons that Professor Goodman was just mentioning, that there's been an awakening about some of the most negative consequences of restrictionist, harsh restrictionist policies, and a really inspiring social movement, in particular in the form of the Dreamers. And so I'm very concerned about the ability of a major comprehensive immigration reform to get through our Congress, in particular because our margin is so small in terms of Democrats, and there are moderate Democrats from places like Arizona that I'm very worried about. And so I've always been more in favor of a strategy that picks off particular issues. And I understand that there are drawbacks to that as well, because that can be thought of as a creaming of the sort of the most appealing, most the poster children, if you will. But because of the extremely pressing nature, as Professor Wadhia has been explaining, this missed milestones, the limbo, the psychological damage that type of uncertainty causes, I would be personally, I would be in support of pursuing lower hanging fruit quickly, because who knows what kind of Senate what the Senate will look like in 2022.
I just want to piggyback and say I don't disagree. I think it's just a really challenging question, but I would just highlight the fact that it will continue to be psychological warfare, because if DACA recipients are able to have a pathway to citizenship, but they're leaving behind their parents, or they're leaving behind older siblings who don't qualify, or members of their families who might not qualify based on like minimal criminal history. And so it just is even more divisive. And so I think that that's really troubling in terms of what that does to our communities and family structures, and making sure that we're recognizing the toll that would take.
Yeah, I would wholly agree with both of your points, but this point of there's something lost, right? Even if something passes piecemeal. I think the only other layer I'll add, well, maybe two, is that, I guess fundamentally it's a question of if everyone who falls within the comprehensive plan can't benefit, is the trade-off that no one should benefit, right? I mean, that's really what we're asking, and I just fundamentally have a really hard time saying no to that question, knowing the complexity of that reality. But I think a second layer too is, even with something that's piecemeal, and this is not a new question, right? This is an old question. What are the enforcement trade-offs, right? So will there be more enforcement or policies that go in another direction in exchange for something more limited? That to me is more problematic and difficult for me to answer. And I imagine that everyone is going to have their own line, right? In terms of this is what is a deal breaker for me, right? And that's what makes the debate so complicated.
I would agree as well. And I don't think we necessarily need to choose between the two. I mean, if you talk to people who are organizing or practitioners, like Laura and her colleagues, I mean, people need as much help as possible in the here and now. I mean, holding out for a revolutionary transformation of the immigration system is not necessarily the way to go, but I don't see why we have to choose one or the other necessarily. And there might be trade-offs to a piecemeal approach versus kind of a larger wholesale reform. But at the same time, I mean, providing people with access to counsel, providing people with some kind of legal status, even if temporary, these make a tremendous difference in the lives of real people today. And to deny them that opportunity seems, like a horrible decision to me. And at the same time, I think if there's one thing that I've learned from the research on my book, and is how this system is inherently problematic and does not work as it should if we have migrants' lives at the center of it and the well-being of the country, and migrants oftentimes being in alignment rather than in opposition to one another. And this relates, I think, to one of the questions in the Q&A as well. But I think we can push for positive changes to the system as it currently exists, while also trying to imagine or envision a system that would not double down on the punitive, profit-driven enforcement policies that have long been at the center of our immigration system. And legalization, a broad legalization program, such as the one on the table or that's been proposed, in addition to provisions for future authorized migration, I mean, that is the most effective way to take away the discretionary power of immigration enforcement agents, right? Is to minimize the number of people whose lives they control. And that would be essentially kind of a response to activists' call to abolish ICE as well. I mean, you can justify winding down the enforcement agency's budget if all of a sudden there are very few people who are subject to their authority. So I think tying together a few of the strands of our discussion today, we don't necessarily have to choose one or the other.
Wonderful. Thank you so much to all our panelists. With the final 8 minutes of our panel, we're going to turn to some audience Q&A. Please, anyone in the audience, continue to submit questions. We'll definitely be going through them. Two of the first questions I would like to deal with both deal with detention centers and kind of something Professor Goodman mentioned about the profit centers of the immigration enforcement system. So Mario asked, what type of healthcare resources are actually delivered in detention centers? What kind of doctors? And then Virgil asked, with detention numbers down, is there not the issue of the mandatory bed statutes that require the US government to pay for a certain number of detention beds, whether or not they are occupied? And so I would add to this, the calls to make major overhauls to our immigration enforcement apparatus, does this require a reimagining of the immigration detention system and potentially, paradoxically, greater government involvement in the detention system to avoid a lot of the issues created by private detention centers? So I'll put that question to Laura first, but certainly anyone join in.
Well, there's a lot of layers to unpack there. Yeah, I mean, I think abolish immigration detention would be like the first step to abolishing ICE. And in terms of the immigration enforcement in this country, I think we also need to, really name what it is and the racial undertones that it has in terms of it's effective because it's a policing of Black and brown bodies largely, or bodies that are, non-English speaking. And so it's like this amalgamation of people who have historically been disenfranchised. And so we're able to have a system of private detention such that corporations are profiting off of stripping people of their liberties. And that, is highly problematic. And so when you're thinking about like, what is the bottom line? That's exactly what I'm talking about when I'm talking about lack of access to adequate medical care. Is when you have private corporations in charge of detaining people, they're not incentivized to offer premium medical care because it's expensive, right? And so I think it's really important to recognize that's at play here, and that's what we're talking about. So, for example, at the facility where I work in Aurora, Colorado, it's owned by Geo Group Incorporated, and Geo administers the medical care. So the other piece about that, I mean, it's actually like wildly difficult to sue because they're subcontractors when there is inadequate care. And it's also hard to like file tort claims within this web of contracting. And it's also challenging because you have to communicate with ICE in order to communicate with Geo. They're trying, it is a system where if you don't have a direct line to the people administering the care to your own clients. And I can't even imagine how challenging it is for family members. I've spoken to many who have no idea, and I'm the conduit of information for them. But when they don't have an attorney involved in the case, it is extraordinarily difficult for them to get answers as to like what kind of care their loved one is receiving. And so I think it's really important to recognize all of these different components of this system that has been built that is not human-centered at all. It's actually the opposite, and recognizing all of the various facets of that, and how even the fact that like at the facility where I work, there is no in-person contact visits for loved ones. So at baseline, people are seeing, if they see their family at all, which they're not right now during COVID, they're not even allowed to enter the facility. It's through plexiglass. And so again, it's just how many different layers of dehumanization can we implement in order to have this system in play in its current state.
Could I just quickly add that, I mean, it really stood out. It was mentioned earlier, but the drop from more than 50,000 people in detention to now 14,000 people in detention. I mean, this shows that, this is a political decision, that the system does not have to exist as it does. There's possibilities to change it, and any kind of excuses as to why not. I mean, these are also kind of laying bare some of the factors underlying this system, and the fact that whether it's private run companies or government run companies, public run detention facilities, the goal should be to abolish all of the above, not just stop at the private, but to really, as Laura Lunn just mentioned, to abolish immigration detention altogether, because we've shown that there's no reason to be locking up tens and tens of thousands of people, and how quickly that can be wound down.
And I'll just, for 15 seconds, say that the drop also shows that it's not just a political decision, it's a discretionary choice, right? There is no legal requirement to detain people. Most of the jails in Pennsylvania are county jails. And right now our family facility at Berks is empty for the first time since 2014. And it is the sharpest illustration that the choice to detain families was just that. It was a choice. And that the agency does have discretion to not detain.
Thank you, Professor Wadhia, for that closing. I think that is an excellent point for us to take away from this panel, is that immigration enforcement in general is driven by human choices, and that we can make change if we can build consensus around it. And hopefully, future Rothgerber conferences can discuss all the positive ways that immigration enforcement has changed. So thank you again to all of our panelists for participating. I will pass it back to Professor Malveaux for the closing.
Great, thank you, Hunter. I appreciate that and all the remarks that were made by the prior panel. So, we kept it strong till the end. So I so appreciate all of the insights and hard work and intellect that people brought to the table today. So I want to go ahead and just close out the Rothgerber conference with some reminders and some remarks. So just some reminders in terms of logistics. For our lawyers that are out there, this is important to them. The conference, if you have attended and you'll have it registered, it is worth 6 general CLE credits, and we're going to be following up with you next week to get an affidavit to you so that we can get that paperwork done. In our follow-up, we're also planning on sending a recording to you. So those folks who did register will have access to the event that has been recorded. And we're also asking that you complete a short survey. We would love to get your feedback on a variety of questions and see how we're doing. Every year we sort of grow and try different things, and we'd love to see how it's going for you. And then the good news is many of our contributors today are going to be publishing their remarks and their articles and their essays and their thoughts in the Colorado Law Review. So we're really thrilled that the Law Review is doing a special symposium issue that will feature many of the work that you've heard today. I'd like to also take this moment to thank so many of you who have made this day, this event, and really the last 2 days so successful. The names they appear at the last page of your virtual program. So if you do go to that link to the Rothgerber program, you'll see these folks, but I really wanted to just kind of give them a shout out loud. They have been so absolutely amazing. And this event would not have happened without a real team effort and sort of a village of sorts to put this together. Obviously, our IT folks are amazing in the background to make this happen and make this go so smoothly. I don't think we really had any hitches today. So I do want to give a shout out to John Sabre and Teresa Coberly for always having our back and being in the background and make us look so good. Thank yous belong to the organizing team, the committee that put this conference together. We've met many months to do this. And it's really come through. So thank you to Kelly Ilsang, to John Griffin, to Doug Spencer, to Seema Sohi, to Violetta Chapin, to David Cook-Martin, to Hunter Knapp, to Julia Roth, and to Yesenia Delgado. I also want to thank our Law Review leadership, the leadership on the Law Review, those who preceded, and the current leadership and the former leadership, Ming-Lee Newcomb, Stacy Weber, Quentin Morse, and Angela Betcher, and all of the Law Review students and editors who rolled up their sleeves and participated. I appreciate your assistance with this. I also want to thank the Rothgerber Fellows who helped with this conference throughout the year, along with the other things that they have done. Neil Sandhu, Leonard Pollard, and Lindsay Floyd. Finally, I want to give a huge shout out to the folks that were most responsible for this event, and that is Melissa Shenter, our events coordinator, who this would never have turned out without her complete support and extremely hard work and diligence. So I'm so grateful to her. And finally, really grateful to my friend and colleague, Ming Soo Chen. She has given us so much food for thought for this entire conference. We could continue to go on and on, but not only has she given us so much food for thought, but she rolled up her sleeves and she really worked hard to make this happen. So I am so grateful for her effort and her vision. So I'm hoping I didn't exclude anyone. Please check the program and make sure that you give shout outs to all of those amazing folks who made this happen. So finally, some closing remarks. I would invite you now to consider how you might get involved in some boots on the ground work that is related to immigration and citizenship. Whether it's legislation, whether it's attending an upcoming rally, doing a monologue, there are so many ways that you can get involved, and you can put your values to work and into action. So you're going to have a chance to learn about some of those opportunities. If you join us for our virtual reception and go into the breakout rooms, you can learn from people who are doing some really important work and maybe figure out a way where you can make a contribution to that work. So there's obviously no dearth of issues that we could grapple with here. I also invite you to join the conversation. Maybe you have reactions to what you've heard today. Maybe you want to share your own ideas or your own experiences. So I'm inviting you to do that. No worries. It is not a formal setting at all. This is meant to be sort of a virtual reception, just a place to get to know others and participate informally after a long day of presentations. So I hope you will consider joining us for our virtual reception. At this point, I'm going to end the official Rothgerber conference. So this is going to be the end, and the virtual reception will take place at another link. So we're going to ask people to exit this particular room and to go into the link that is posted in the chat is cu.law/Rothgerber reception. And the person who will be facilitating and helping us navigate that reception is my colleague, Doug Spencer. Doug Spencer is a professor of law and public policy at University of Connecticut. He has been here, however, at the University of Colorado Law School as a distinguished faculty fellow, helping us with our programming. And he is going to be responsible for the breakout rooms. A little bit about Doug. He's an election law scholar. His research deals with prejudice and racial attitudes in voting rights litigation, the empirical implications of various campaign finance regulations, and the ways that election rules and political campaign contributions contribute to inequality in our country. He served as an expert witness. Prior to teaching, he interned with the Lawyers Committee for Civil Rights in San Francisco, was an election monitor in Thailand, and a researcher for the Pew Center. So Doug is, Professor Spencer is going to be sort of hosting that virtual reception. So I am going to ask folks at this time, if you're not too burnt out, please join us. Again, informal, relaxed. We'd love to have you join the conversation. So please take the time now to exit this webinar. And if you're on the YouTube live stream, you can end that and just go ahead and put in your browser cu.law/Rothgerber reception. Rothgerber is ROTHGERBER reception. And join us there. We look forward to seeing you at a virtual reception.